Hello everyone, it's Anthony Bandiera here, attorney and senior legal instructor for political law enforcement training, bringing the Roadside Chat. And now I am on the road. I'm in Corpus Christi at the TCOL conference, Corpus Christi, Texas. Right behind me is actually a aircraft carrier from World War II. So it's a great environment. The ocean's right here. Fantastic conference. This question comes from a citizen, and as you know, I don't mind answering questions from citizens and law enforcement, even though the bulk of my questions come from the law enforcement environment and profession. I don't mind answering questions from citizens as well. The citizen's saying, hey look, he's the person's from Virginia. Can police lie about the reason for a traffic stop? And so he says, look, the cops see somebody suspicious and they want to identify that person. And they pull them over for a fictitious crime, right? Crime or infraction, let's say running a stop sign. But the person, in fact, did not run a stop sign, but that's what the cops are saying. And they get their license, registration, and insurance. And the person provides that and then gives them a verbal warning, thus kind of avoiding the whole, paperwork trail. Would this violate the Fourth Amendment? And the answer is yes, if the officer did not even have reasonable suspicion. Now, if the officer has a hunch, and a hunch is a slight possibility of criminal activity, but cannot be used to search or seize, right? But reasonable suspicion is a moderate chance of illegal activity and must be articulated. So here, if the officer is actually working off of a hunch and has no reasonable suspicion, then the stop itself is illegal. And what can be the consequence? The consequence is a civil rights violation. Now, you may be thinking to yourself, but no harm, no foul, I guess. If the person was just let go with a verbal warning, there's no court case. Well, that's true, and the way that you would rectify this and vindicate your rights would be to file a complaint with IA, see what happens there. If you're not satisfied with that, you would have to go and seek out an attorney to potentially try to seek, a civil remedy. But make no doubt about it, if the cops did not have reasonable suspicion, this is kind of like a game that they're playing just to ID people, then obviously that'd be unlawful. At the same time, cops do lie, right? And I shouldn't say it like that, but cops lie to forward an investigation. I mean, think about a cop playing the role of an undercover drug buyer, right? They go to a drug dealer's house, they knock on the door and say, hey, can I buy some drugs? And the drug dealer says, hey, are you a police officer? And the undercover cop says, oh, of course not, right? Well, why would I be, I'm here to buy drugs. That's a lie. Is that legal? Absolutely, right? Otherwise, you can't really, it's hard to fight crime when you're forced to tell the truth every single instance. Here, though, this is not really the same type of situation. A person should know, before they leave that traffic stop, they should know the legal basis of their detention. Now, is it strictly speaking, a civil rights violation to not tell that person what the legal basis of their detention was? No, I've never seen a case that have held that, but is it unprofessional? Absolutely. Is it potentially violating policy? Maybe. Is it potentially violating state law? Maybe. There actually may be some things in there that the plaintiff here could argue, or the driver could argue, that these things were violated. A person should know why they've been detained, even if not initially. So for example, the cop makes the traffic stop and the cop is being very ambiguous about why the stop occurred. We identify the person, we determine that they were not engaged in criminal activity. Then the cop says, hey, by the way, the reason I did stop you is because X, Y, and Z. That's why I stopped you. And the final point is, if you are going to make these like pretext stops based on reasonable suspicion, even though the person is ultimately dispelled, the suspicions are ultimately dispelled, you should make some documentation somewhere, CAD note, maybe the video, something to justify your detention. Otherwise, you may forget why you detained the person, a year, 2 years from now, if you're being called to the carpet on him, okay, or in a lawsuit. I hope it helped. Keep the questions coming. If you have more questions, go to bluetogold.com/show. Please hit the like button, subscribe, share with your friends. Until next time, my friends, you stay safe.